It has been my stance and my belief, and council has, by a majority vote of council, said that we did not authorize the signing of that settlement agreement. And there has been 4 of us that have passed a resolution, and it's in our official record of the city, stating that we did not authorize the signing of that agreement, nor could we have in closed session, nor had we even had seen it at that point. And I know you and I had discussed somewhat to the effect that there would possibly be an Open Meetings Act violation because of that, because it's never come in front of this council, and I wish you would elaborate just a little bit on that and the authorities of signing documents by municipal city council.
I'd be happy to. The Open Meetings Act issue is a touchy one for municipalities, but the law is pretty plain as compared to the whole field of adult business regulation. The Open Meetings Act is
not as confusing.
Right. I'm going to just quote a couple of provisions. The general rule of law is that an attorney is not automatically authorized to settle a case. The almost unanimous rule laid down by the courts of the United States, both federal and state, is that an attorney at law has no power by virtue of his general retainer to compromise his client's cause of action, but that precedent, special authority, or subsequent ratification is necessary to make such a compromise valid and binding on the client. Broad general statement. There's a more particular one for municipalities. A municipal attorney does not have independent authority to enter a consent judgment for a municipality. And then this is a quote. As a matter of law, a city attorney does not have the independent authority to enter into any type of consent judgment or settlement without prior approval of the appropriate city authorities. That's black-letter law from within the state of Michigan.
And you're reading, what is that you're reading, the Open Meetings Act?
No, that one was out of a Court of Appeals case from the late 1980s.
Okay, and that was the one that is at the Coate versus Drake, I believe, that you...
I just turned the page away from it, so...
From that opinion that you got.
Yes.
So,
Coates and then City of Detroit versus Gorno Steele. And the principle there, the reason I quoted those for you is that it's very clear to me that a city attorney doesn't have any independent authority as the city attorney to go out and settle cases for the city. The city has to give authority to settle a case or cases. That much is clear. In your particular setting, you folks had a closed session meeting in which everybody seems to agree there was you went into closed session to discuss the strategy of this case. That was the discussion in it. You can't have a decision in a closed meeting. The Open Meetings Act doesn't allow you to do it. So you had to come out of that closed session, and if you were going to make a decision to settle the case, you should have done it in open session right afterwards, which didn't happen.
And it still hasn't happened.
Just didn't happen. That means only one thing to me, is that there's been no formal decision by this city council to settle the case.
But it's signed and it's settled.
It's settled over in federal district court.
That's right. I know.
So,
do you think that our city attorney who signed that agreement without our knowledge should have been aware of the information that you just gave us?
I'm sure he's aware of the general practice in Michigan and standards. He explained to me that the actual practice here in Lincoln Park had been to brief the city council and settle cases, and you don't come back and get formal expression of authority. It had not.
Well, does generally cases of this nature require outside, if your insurance legal counsel is there representing municipality, they went one step further in this case. They asked for city officials to acknowledge that they have discussed this, that they have read this, their attorneys of record have went over, and additional signatures of city officials. And that's a new one that I'm seeing, that from the cases that I've read, I haven't seen that.
I missed the question.
Where the plaintiff actually required additional, when our insurance carrier could have settled the case, whether we liked it or not, they could have settled the case.
I think that's correct.
Okay, so they went one step further, and they said, you know what, we don't want to just do that. We want to make sure your city officials have read this agreement, their council has explained it to them, And they further authorized Mr. Duchesne and Mr. Zelenak to sign it. Is that something you see commonly done? Because I haven't seen that.
I'm not sure I've seen it commonly. I have seen it, and I have seen it in particular in the land use type cases where cautious attorneys will insist that the municipality somehow certify that they've done what they're supposed to actually settle it. It's an open question as to what happens when they haven't, like what you folks have gone through. For whatever reason, past practice here developed in a way where you didn't finalize your settlement authority on the record. It's not a preferred practice to do it that way.
We've asked several times for documentation from Mr. Zelenak, and we haven't had any forthcoming. And last night, Councilman Mike Myers was told that Mr. Zelenak was not going to provide that. And he further said just last night that your report stated that he was authorized to sign the settlement agreement. And I went over that, and your report says to me, Mr. Zelenak states he was authorized, not that he was authorized. And I do want to clear that up. In the information you just read to us basically says, no, that's not the case. He may say that he was, but that's not what I read in your opinion.
That part gets to you're correct, and it gets back to the Open Meetings Act question, because in the closed session, you can discuss settlement strategy and tactics, and you can authorize the attorney, yes, go out, try and settle, this is the way we want to do it. But what that does not involve is a formal decision to settle. That can't happen in closed session. You have to go into open session and do that. Still hasn't happened. Now, Mr. Zelenak may very well have heard, and that's what he says he heard in closed session, part of his settlement discussion and strategy with you folks was to settle the case. And so he thought he was supposed to go do that, and he took that as authorization. And that may be splitting hairs, but obviously you folks didn't ever vote to approve the settlement. That has to happen in open session. Part of what got missed in this process locally was the way you went from closed session to settlement without the public session discussion of the general terms of the settlement agreement, is you missed that opportunity for council members to question, focus, debate a little bit in public what was happening. And sometimes cases like this require that to get a full airing of the issues. It can be ugly, controversial, but sometimes it's just needed to get it done.